Hey, right, everyone. I think we're up and running. Welcome to the live stream this week, guys. Usual sort of stuff. Please don't share personal data in the comments. So let me just do these bits actually. So yeah, let's put that in there. Oh gosh, here we go. Um, and then just bear with me. Got to do this one over here as well. Excellent. Right, yeah, cool. Yeah, welcome everyone. So no personal data in the comments, please. In the live chat, ask questions as if they're about someone else. You'll get a better answer, and it means you don't have to put your personal data on there. Hey, what's the back? I'm well, thanks. I hope you're doing all right, mate. All right, mate. And just to say, it's not legal advice. We're doing our best here to give you some information which can be helpful, but we can't obviously guarantee the accuracy of everything. So yeah, so we'll kind of muddle through. Also, just to say, if you want to get a question on the live chat, do it sooner rather than later because I will. As I've done the last few weeks, I kind of like put a cut-off point just to make sure we're not rushing through it and we actually do justice to the questions that are coming in. So hey, what Tiff? Um, so questions that have come in from the channel first of all. So just to reiterate, if you ask your question on any video on this channel in the week before like 5 o'clock on a Thursday, I'll get a notification. You then don't have a character limit, so you can kind of ask long questions potentially, although don't make it too long. And yeah, and basically, I'll guarantee you we're gonna give it proper time. So yeah, getting on with it then. First question is coming right up when I share my screen. Here we go. So, oh, what's that doing? There we go. Cool. So yeah, first question for this week. Excuse me, I'll zoom in a bit as well. So if you make, so just to give you a bit of context, this question is based on the video I did this week where I compared local connection criteria from part 6 and part 7. It's kind of part of an effort of me trying to find a way of like explaining this stuff because it's ridiculous and it's just quite difficult to sort of explain how part 6 and part 7 interact. So yeah, so well done to anyone who actually followed it. But yeah, so this is the question. So if you make a homeless application, you're automatically treated under part 7 no matter if you're classed as priority need or not. What happens if the decision is made you're not in priority needs? Are you automatically then downgraded to part 6? What if you already applied? Um, so I might come back to that because I think that question comes up later. Before you made the homeless application just to register, but never got a confirmation it was already received. If you then make a homeless application, you should then obviously be dealt with under part 7, if I understand correctly. So really good question. I might just get into the code of guidance as well to give this a better answer. But essentially, yes. So, in fact, I will go straight to the code of guidance because it makes sense, doesn't it? Hold on. So, stop sharing that one and get this one up here. So yeah, so just to let you know, guys, for those who haven't been to the stream before, this is like the go-to document for housing law. It's you can just Google it, it's free. Why is it not zooming in? There we go. And this is what you get. So if you just Google homelessness code of guidance PDF, this is what you get. And if we go down to 18.6, no, 18.6, get there in the end. This is what it says. So housing authorities should take particular attention to identify instances where information on an inquiry about a social housing allocation scheme or an application for an allocation of housing under Part 6. So just let's pause that there. That is unusually complicated for this code of guidance. That is basically saying if you apply for council housing in some way, so social housing, which will often be done through the council's online form. So if you go on the council's website, say I'm homeless, they'll often direct you to this Part 6 application form, which is already not exactly the best practice. Um, so essentially, if I reiterate it, so if they identify instances where what that type of application provides reason to believe that the applicant might be homeless or threatened with homelessness, this should be regarded as an application for homelessness assistance. So what this is basically saying is if you go on the council's website and fill in their normal housing allocation, housing register application form, but in doing so, you tell them that you might be homeless, and you don't need to use that word. You can say you're experiencing domestic abuse, or you say you can't afford your property, or you can't, or you got like really, really bad damp and mold, and it's affecting your breathing, or you're really overcrowded. All of those kinds of bits of information, although you're not using that word homeless, that would give the council reason to believe that you might be homeless. And so what this is saying is that council should have a system in place which flags up those kinds of issues and gets essentially they would need to get a human being looking at that application to see if actually there is reason to believe that person might be homeless. Because bear in mind, the homeless application itself is triggered if you ask a council for help with housing, which filling in the online form would do, and you give them reasons to believe that you might be homeless or threatened with homelessness. So that's kind of what this is really saying. So these are kind of, I mean, 18.5 is actually the most important paragraph in the Code of Guidance, I would argue. So if we go back to the question, if you follow me so far, so if you make a homeless application, you're automatically treated under Part 7, no matter if your class is priority or not. So the answer to that is yes. That's the default position anyway. Now, there is a really, really bit of obscure case law which says that you essentially can insist that you are dealt with under Part 6 in that circumstance. And the reason you might want to do that is you are legally homeless, but you're actually, kind of okay for the time being, and you'd rather stay in that situation rather than move into temporary accommodation. The benefits of doing that is that you essentially get more choice when it comes to bidding, because, let's say the council owes you a main duty, which, that's what that means. First of all, they can discharge that into private rented accommodation anyway, but secondly, they can give you very little choice on the housing register. So to say, that's kind of the one situation I can think of where you'd actually be better remaining in Part 6. Let's say you're staying with family, it's only a medium term like solution. It's not, it's not like it's not settled accommodation, it's not reasonable to continue to occupy indefinitely. But that's how it was. So yeah, so that should be the case for anywhere. So I mean, I've probably talked to at length before about cases I've been involved in where that was the first mistake the council made. Someone went onto the generic default Part 6 application form, but told the council they might be homeless, and the council just left them be homeless for years, during which time they came to significant harm. So yeah, irrespective of whether you're in priority need. So that's the first part of the question. What happens if the decision is made you're not in priority need? Are you automatically then downgraded to Part 6? So not immediately, because and to answer this, I'm probably going to go to the Bedford Borough Council housing allocation schemes because it's a good example. So bearing in mind that the relief and prevention duties are owed to people who are homeless and eligible, irrespective of priority need status. And whilst you're either threatened with homelessness, as in under prevention duty, or you're actually homeless under relief duty, you get something called reasonable preference, which is essentially a guarantee that you're going to get onto the housing register at some level. It might be the lowest band, but you would get onto the housing register. This is when we depart. It will then depend on the council's own policy. So, in fact, if I get Bedford's policy up, if I get the right screen first. So, this is. No, it's not. Come on, where are you? Here we are. So, this is Bedford Borough Council's housing allocation scheme. Every council has a different policy, and you in Bedford Borough, and this is not the. Yeah, you have to check your own council's policy. You would get band B if the homeless duty is accepted, which means, as in the main housing duty, which is when you're in priority need, you're not intentionally homeless, you have, local connections taken care of or whatever. But if you're not in priority need, you would effectively come under band C, because band C would be given to someone who's homeless or threatened with homelessness. And as it says here, applicants who are homeless or threatened with homelessness within the meaning of the Part 7 of the Housing Act, which is what we're talking about here. So Part 7 is all about homeless applications and the definition of homelessness, and or the council owes a prevention or relief duty. So whilst you're under prevention or relief duty in Bedford, you'd get band C. And even when the prevention and relief duty ends, if you're still homeless or threatened with homelessness, which can happen, you would still remain in band C. So I think I'm answering that part of the question. If I go back to the questioning, because obviously there's quite a few different parts to this one. So you're right. So that kind of, I'm hoping that deals with this part of the question here. And then what if you already applied, as into the housing register, before you made a homeless application just to the register, but never got a confirmation it was already received? So this might have, this is actually quite common. So people, they need like, or they want to get social housing, so they apply to the housing register, and then 2 years later they're sitting there like lowest band or whatever, but then they actually become homeless or they become threatened with homelessness, and so they make a homeless application at that point. Now, again, there might be some councils that do it differently, but in my experience, what the council will do is they'll take it as a fresh homeless application from the start. And even if they owe you the main housing duty or whatever, they'll basically give you that banding from the date they make the decision of the homeless application. So in effect, however many years you've been on the housing register beforehand will just be wiped away. It will not matter anymore. So again, I'm not aware of councils that don't do it that way, but I guess there might be some, I don't know. And then that last bit, you're correct. So I'm hoping that answers that question. Shannon, Will, or Karis, have you got anything to add to that? Or No, get shakes the head. Okay, cool. So that's question one done. Question two. I think this, okay, yeah. Um, if someone is deemed non-priority and has nowhere to go but the streets, but has a full household of items plus a pet and can't afford paying the storage costs as receiving universal credit, could you expand this? So this is a comment put on a video about protection of property. And I actually don't know the answer to this question, but I do know where to find the answer. So we're going to go back to the Code of Guidance to chapter 20. Let me go a bit quicker than that. Hold on. So I think it's the shortest chapter of the Code of Guidance. So chapter 20, protection of property. This chapter provides guidance on the duty and powers housing authorities have to protect personal property of an applicant. So under section 211, where a housing authority has become subject to a duty to an applicant under specified provisions of Part 7. So unless it's, oh yeah, here, so the specified provisions are section 188, the interim accommodation duty, section 189, which is the relief duty, or section 190, which is the duty owed to people in priority need but intentionally homeless. Section 193 is the main housing duty, and section 195, I believe, is the prevention duty, isn't it? I think so. That's weird. I don't know why you'd need your belongings protected if you're under prevention duty, but I guess it might happen. So those are the specified provisions, and then it goes on to say, and it has reason to believe that, first of all, there is a danger of loss or damage to the applicant's personal property because the applicant is unable to protect or deal with it, and no other suitable arrangements have been or are being made. Then, whether or not the housing duty is still subject to such a duty, it must take reasonable steps to prevent the loss of or prevent or mitigate damage to any personal property of the applicant. Now, in my experience, and the others might have some different experiences, councils, certainly I think Bedford Borough Council would effectively pay for upfront, transport or like storage costs, but then would charge the applicant whatever that amount is. It might be kind of done as a loan in effect, and you then repay it over years. But the way I'm reading this is that if you were not in priority needs, but you're subject to the relief duty, so that would kick in here, and these three all apply, then that duty to protect your property effectively would continue to, as indefinite there, as far as I can tell, because whether or not the housing is still subject to such a duty. So the relief duty could end, but the way I read this is the duty to protect property would continue. That's, as I say, I've not seen it kind of go that way before, but that seems to be what the law is saying. Again, Shannon Willock Harris, feel free to add to that answer. But that's how I'd give an answer to that question. And just to say, pets are like technically their personal property. So I'm not quite sure how you store a snake, but I guess that's the council's problem if they have a duty to do so. So yeah. So hopefully that's question two answered. Let's get back to question three then. Hold on. So question three is, okay, this is more, this is a question. This is one of my favorite questions ever, actually. So I'm waiting for an FOI response asking how many homeless people were brought train tickets before they even had a housing application started. My concern is that people, it's a local authority commission charity buying the tickets. I may not get the correct answer. You can't ask a charity directly for an FOI. If I asked this at committee and they didn't have figure to hand, would they answer it in the next meeting? So this, as I say, this is a really cool question because this is someone actually having a little sniff around the local policies and practices of councils and charities. So just to give you a bit of context, one of the first cases I got upheld involved Folkestone and Hythe. No, it wasn't. It was, sorry, Shepway District Council back then. And basically, a lady who was fleeing domestic abuse, who was pregnant, went to their council. There was an immediate duty to house her, basically, but instead they got a local charity to fund a bus ticket back to Bedford, which is where she was at risk of abuse, which was awesome. So she did get compensation for that, and the council did have to go on training because of it. But that's what we're talking about here. So I'm pretty sure Bournemouth used to do this. I don't know if they still do. Quite a few of the South Coast places, I think, do this as a way of just kind of gatekeeping without getting caught. So, in answer to your question, first of all, charities aren't subject to FOI, so you can ask them, but they probably won't have to answer you. Well, they definitely don't have to answer you. They might do it if you wrote to the trustees or something and made a bit of a fuss about it. But what you might be able to do is to design the question you're asking the council, because although they might not be buying the bus tickets, if they're funding them, you could say, does the council fund other charities to buy bus tickets? And if so, how many have been funded? Because I would have thought in most cases the council would be tracking how many tickets they're paying for. So that'd be maybe how I'd approach that. And you can also ask it in the committee. And yes, if I mean, they won't have it to hand, obviously, but they would then they should provide it at the next meeting. That's one of the reasons why, if you're asking council committee meetings like questions, if you submit it enough with enough time in advance, they might be able to kind of respond between then and the actual next meeting, so they can respond a bit quicker. But yeah, again, I realize I'm just doing all the talking at the moment, but does that make sense? Yeah, cool. Getting nods. So question 4, Shannon, can you keep an eye on the live chat just to see if it's getting like we're going way too many questions, because we're gonna have to kind of keep it fairly concise. I think this is more an observation rather than a question, but I thought it's useful to include there. So it never ceases to amaze me how abusive people with callous disregard for others seem drawn towards position of power and control. It's a pandemic and it's gone on long enough. People are dying or living with extreme trauma due to housing officers breaking the law and denying people safe housing. We need housing officers to be experts by experience. Now, I think probably we don't have time to kind of explore that fully tonight, but I think it's an interesting point, and something which, if it was done correctly, I think could lead to better services from councils. I think the danger is you throw someone in with lived experience of homelessness and they just get chewed up by the system and they end up kind of getting spewed, chucked back out again. But that may be something we can return to another week or something. I don't know if you guys have got any pressing kind of comments you want to make on that one at all.
Perhaps I agree with it.
Oh yeah, cool. Yeah, Will's in agreement. Cool.
I'm in agreement, and without going on too much of a rant, but I think lots of local authorities fund and commission trauma-informed charities, and they'll put it into bids and stuff that any charity like has to be trauma-informed or psychologically informed environments and all of this, and then they're not doing that themselves. And so I think potentially it's, again, like linking back to question 3, but it's potentially an FOI into what training has your housing officers had on re-traumatizing people, on vicarious trauma, on trauma-informed environments, on all of like person-centered approaches, all of this sort of stuff. That's potentially an FOI. And then raising it in the housing committee and saying the FOIs come back to say they've had no training on this. Do you think that's appropriate in the current climate? And I'd imagine they'd say, oh no, it's because it's really good, but behind the scenes they'll run away and do some training. So again, with something like this, like, absolutely be angry, but I think there's also things you can do potentially about it in your own area that will have quite a big impact.
Yeah. Cool. Yeah, I agree. I am going to do a video at some point. There's an LGSCO decision which cited the shitty trauma and uninformed response a domestic abuse survivor got. I think it was Norwich. I might be wrong about that, but I'm going to dig it out and do a video about it at some point. So even the LGSCO is kind of like something they're picking up on. So you're right, Martin. You're right. I was just going to do the rounds here. So I think we've got Cheeseface. Hey, you got Cheeseface? So Martin's just put in there that, where's it gone? He just put a comment on there about FOIs and charities. So it says if a charity is performing a statutory function on behalf of the council, then the FOI exemption doesn't apply, as essentially they become a contractor. So
it's whether they're counting it as a statutory function, though, because if they're not accepting the application, they wouldn't count it as a. Because when I was doing the Now Medical thing, they tried to be like, no, it's a complete, like, one council is like it's a completely separate thing. We don't have to give you the information. I was like, well, no, because you're carrying out a statutory duty. But I think in this situation, I don't think, because there's no homelessness applications being made in the first place, they're not seeing it as a statutory thing.
Yeah, because in one sense they're specifically doing this to avoid the statutory duties. It's a bit like rough sleeper outreach teams get effectively verification. Yeah, if they're basically gatekeeping by proxy, but they probably wouldn't. Yeah, they'd argue that they wouldn't come under that kind of ambit. So, but yeah, no, it's just, I mean, it's good to think about in general. So thanks, Martin. That's helpful.
Mike, there's just a comment at the end that you might want to delete on the channel just because it's quite personal.
Yeah, cool. Just to reiterate, guys. So just it sounds like me really horrible, but basically, there's a rule here in terms of putting comments on there that you don't share personal data. So you can absolutely ask questions about your own situation, but you just need to pose it as if it's about, what if questions. So what if someone was in this situation or whatever, and what would the answer be? That's a better way to get it. So if that person wants to just rephrase if there was a question in there, just to rephrase it in the third person, that'd be awesome. So next question, what are we on 5? So our council do not allow us bidding on properties. Okay, I'll come back to that. So they advise that we need to wait when we will be evicted. Section 21, I think that means we pay for the rented house, but our landlord would like to sell it. I don't want to get bad references as a tenant. How can we approach the council to allow us to bid as we previously was promised? So yeah, I mean I'm going to give a very short answer to this because there's a video about this on the channel which will probably answer it better than I can now. But if you search for the channel on the channel for the word bailiff, there's a video which is like, I can't remember what it's called now, but it's got bailiff in the title. It's the only one. If you watch that video, it kind of gives you what the law says. But basically, you can make an application if you are either homeless or threatened with homelessness, and you're threatened with homelessness if it's likely you're going to become homeless within the next 56 days, and that would include where a valid Section 21 has been issued and it's within 56 days of it expiring, which is probably going to be quite likely because they tend to be 2 months anyway. So, and as I said already, for the answer of whatever question it was, like question 1, if you're owed the prevention or relief duty, you will have to be on the housing register at some point. Now, the point the person's making here is very valid in terms of if you stay put. I mean, the council will probably tell you to stay put, but that's actually bad advice. And that bad advice can mean that you're subject to court fees. It can, in theory, I think, mean you're subject to kind of legal fees if a landlord instructs kind of solicitors or whatever, or lawyers or whatever, to act on their behalf. And the whole, as we heard from someone who's been very helpful kind of last couple of weeks, the whole point of the Section 21 process is it's supposed to be kind of amicable. It's supposed to be kind of a way of getting people out without there having to be kind of high legal costs. So I think if you watch that video, something bailiff, I might just try and dig out a bit later as well. But that will kind of give you what you need to know, what point you're actually threatened with homelessness, what point you're actually homeless, and some examples of councils having to pay compensation when they advise people to stay after the Section 21 expiring. But you should be able to bid on properties in the prevention duty, which is before the Section 21 even expires, even though it might be at a very low banding. It might be like the bottom band or the next bottom band. So, and then finally, and this is a really good question, but I don't know if we're going to fully be able to answer it here. So following a mental capacity assessment, where it had been decided that somebody lacks capacity, and then going into best interest for decision making surrounding where to live, if that person has no family nearby, does that person have a legal right to move closer to family in the UK? So I think the short answer to that question is, yeah, that's kind of how the local connection criteria has been designed. So you've got residency, but you've also got family connection. So most areas, if they'll say if you've got if your family's lived there for 5 years and it's close family, then then you would have local connection under that criteria. Again, watch that video I did a couple of days ago about how that might change, because I gave some examples of when it's more strict than that. The question actually we probably hasn't actually been asked here, but the issue that might crop up here is that a council you apply to under housing law will probably say, oh, this person lacks capacity and therefore they can't make a homeless application, which that is true in itself, but that isn't the whole story. So, and I guess to say that I'm not sure to what extent this kind of it kind of reflects the law, because people you can only lack capacity about a particular decision at a particular point in time. You can't just lack all capacity, or if you can, it's not something you're going to see very often. It'll be something which is decided by kind of like a very specialist kind of whatever. I don't know who would do it, but so anyone who can approach the council, and if the council is initially going to say, well, they don't have mental capacity to make a homeless application, they will try and sort of wash their hands of them. But actually, that's not the end of the story. The council will have to support the person to make a decision. They'll have to kind of revisit it, kind of see what else could be needed to actually help the person make a decision. And if that person still doesn't have capacity, then you can appoint a deputy. And there is something which I've heard of, which I've not checked out yet, which is just like a fast track way of getting a deputy, because taking a deputy can take ages. But yeah, but potentially it might well be that actually it's going to be adult services who would be the ones who are sourcing accommodation in some circumstances. and I don't see why they would not. Yeah, they would not be held to. Yeah, they would be able to kind of. In fact, they would probably be bound to take into account the person's family support network as part of the promoting their well-being. So I think either way, the answer to this question is yes, but how you actually get there might be a little bit more complicated. So yeah, cool. Right, that's all the questions from. How you right, Renee? From the week. Let me just see how many questions we've got and if we need to just. Right, I think. Oh, sorry, say that again, Shannon.
I was saying there's quite a few.
Yeah, I think we're going to just call time on uh, more questions at this point. If we do kind of rattle through them, then great. No more questions from this point. So if you want to ask for additional questions, just put them into a video on a comment on the video, and we'll get to them next week. So I'm not sure people will see that, but anyway, let's go back through it then. So okay, so this is I think is a multi-part. Let's just piece it all together. So okay, I think that's all of it. So let's go through this. Question 7. I know somebody is autistic and diagnosed with severe anxiety and with depression. He is now homeless and has completed a homes application and has now been granted interim accommodation. The problem he has is that he is a very difficult housing officer, but he has an OT report and other supporting letters highlighting sensory needs and how he'd need a self-contained accommodation and to stay in the borough. How long will it take for the council to make a decision? And could this difficult housing officer still regard as evidence or disregard as evidence, sorry, and award him a shared accommodation or accommodation outside the borough? So I guess the real answer is they may well do that, and you may well have to challenge it. The legal answer is, and I know I'm going to leave this to Will actually because Will's dealt with this kind of thing and as a solicitor. Because I think my answer is going to be you're going to need a solicitor most likely to argue with the bad housing officer. So Will, could you have a crack at this one? Because as I say, I know you've kind of talked about this one before, or this kind of
Yeah,
issue before.
yeah. I mean, the answer again is if the question is, could the difficult housing officer disregard the evidence and award him shared accommodation? I mean, the answer is strictly speaking, no, if it's strong evidence, but they might still have a go. Um, so the real question is, could you successfully challenge the difficult housing officer if they did that? And what you'd have to be able to show, and maybe the OT, well, the OT report may not show that. You're going to have to show that somebody has their circumstances are such that they do need to be in the borough, and also that shared accommodation might be unsuitable for them. So the OT report may be relevant to shared accommodation, but they generally just comment on the sort of physical setup of the accommodation. So whether the person needs level floors, no stairs, and that sort of thing. But I would say to people, if you've got a support network, and there are people that you need to be in touch with in the borough, then get as much information as you can about them and from them, because councils and judges have sort of heard the word support network used a lot, but often it doesn't materialize into anything other than a description without people actually being identified. So if, for instance, you've got somebody that's got therapy and it's taken them ages to build up a relationship where they trust the particular therapist, it's not good enough for the authority to say, oh, you can get a therapist anywhere you like. So I'm sorry it sounds vague. I spend a lot of time explaining this to people and I never feel very satisfied because you just don't know. It partly depends on the authority. I mean, some authorities have a sort of policy of sending people out of the borough, whereas on the basis that they haven't got anything local and they're terribly sorry, but the only stuff they can find is in Stoke-on-Trent. But somehow the neighbouring borough seems to have little problem housing people locally. So it's difficult. If you can get a part-time job, I appreciate that the more vulnerable you are, the less likely you are to be able to do that. But that it's working in the area. If you've got exams in the area, if you've got people that you actually rely on a day-to-day basis, and try and get as much evidence as you can, and then it's harder for them. As you say, the key thing is whether somebody can disregard evidence. And the more evidence you've got, the closer you get to the legal term, which is called irrationality or perversity, which is a little bit misleading, but it's meaning that you're failing to have regard to relevant information or having regard to irrelevant information. So that's my answer to that. Is it they may have a go at giving you shared accommodation outside the borough, but the more evidence you have to show that that's unsuitable, the better chance you've got of challenging it.
Thanks, Will. Does anyone want to add to that answer at all? Shannon?
Not sure how useful it is, but I think there's a lot of like misconceptions around sort of autism, and particularly when we say like sensory needs, and often people think like sensory needs, oh, like that's like quite child things and labels and clothes and things like that. But actually, having worked with like quite a few autistic teenagers and stuff back in the day, the sensory needs a lot of the times when we had issues were when we were going somewhere new, because it was a sensory overload of not recognizing even like the local bus going past. It's a different bus at a different time, and then that would cause sort of a sensory meltdown, if you like. And so I think, I don't know how good the occupational therapist report is, actually having some evidence of why the location would sort of affect the sensory needs, and whether that's actually the routes to and from the GP surgery is well known, or the buses are well, whatever it might be, or you live near a train station and you're used to that sound, or like all these different things that like you don't necessarily think of. And I think particularly when you're close to someone who is autistic, you're sort of just used to that. But actually sort of really slowing it down and thinking about, right, how would they feel and what would it feel like for them if they were in a completely different location, and what triggers would that have on their anxiety, their autism and depression. And then you're talking about the impact and that negative impact and how those conditions will be made worse. And I know we're not talking about priority need here, actually laying it out in that argument, particularly obviously talking about the Equality Act and disabilities and everything else, like that's potentially a bit of evidence I'd be trying to go for, if that makes sense.
Makes loads of sense, yeah. I wonder as well, like what local services there might be for people with autism. So again, like I'm trying to think if Bedford Borough Council still has an autism adult services team. I can't remember if it does or not, but certainly there are charities that kind of, in Bedfordshire, Autism Bedfordshire. There's going to be kind of support that they can give, and potentially some supporting evidence they might be able to give if they were to be, getting to know someone, and or certainly if they know someone for some length of time, just to kind of actually be able to kind of support that stuff. I mean, the medics are always, they're going to hold more weight, and the OT is going to hold more weight if you can get that level of information. But I guess, as Will's going to say, you want to kind of maximize the amount of information you have in general. And we haven't seen here about whether the person's getting support from adult social care. But I'd say as well, like there's absolutely nothing to lose by asking for a Section 9 assessment under the Care Act from the local authority. And they gatekeep as much as housing do sometimes. So it's not like a smooth journey. But if you get a decent social worker who carries out an assessment and kind of looks at these different things, not only will they be able to give you advice about kind of local services that might help you out, and information that will help out, but that assessment in itself might actually kind of help them as well, or help you kind of provide evidence to the housing team. So yeah, if I had like infinite time, I'd like to do like get some experts on autism together and kind of do like a homelessness law session, because it's so many different ways it can kind of interact. So, but yeah, as I said, I don't know, I've not
Particularly
got
when you
time
think
for
if
it.
the masking comes along with a lot of sort of people who have autism and stuff, like the masking, and you can imagine in a sort of housing options interview, can't you, going, well, you seem all right now, and you're like, well, spent my whole life masking, like whatever, like, yeah, it'd be an interesting discussion.
Yeah. Cool. Yeah. I mean, hopefully there's some stuff in there that's going to help. I mean, I guess the default is as well is if you can get a solicitor, then that's not going to hurt either. What was it? Oh, this is going to annoy me. Why is that not doing the old gap now? Hold on. Sorry, guys. I can't live with that. No, it's not doing it. Okay. Anyway, well, we're going to have to live with it. So question 8, What happens after notice to quit from council? How long will it take for eviction? So I think we've kind of answered this question before. So in terms of the actual timescale of a Section 21 process, which I'm assuming what we're talking about here. So I think technically notice to quit is like a part of that process, whereas I think most people would take a notice to quit to mean the Section 21 notice itself. But I think we established, I think we just say when we last answered this question, I think the quickest it can happen is like 3 or 4 months. And because courts are, I don't know if they're still backlogged or whatever, but they seem to be pretty tardy. So it can take, it can take a lot longer. Will and Karis, what's your experience at the moment in terms of Section 21 processes from Section 21 being issued through to, kind of having to leave? Are we still talking like 6 months plus? Is that kind of typical?
You have a shot, Chris?
Oh, Karis, you're mute if you're trying to unmute. That's all right. Okay. So yeah, no one's saying that otherwise. So I think that's sort of timescales.
The other thing to think about is with the notice to quit from the council is different from Section 21.
Okay.
Because if your Section 21 is only for landlords of assured short-hold tenants, Section 21 Housing Act 1988. So if the council want to evict you from a council flat, that can take a long, long time because it's a month. I think it's generally a month of a notice, or maybe 2 months for a notice of seeking possession if you breached your tenancy, and then they'd have to take you to court and they'd have to prove it because most council tenancies you have to show it's the breach has happened and it's reasonable to evict. But the one that's quite common in this area is the notice to quit for the temporary accommodation, Section 188. And that's similar to Section 21, except because basically as long as they can show that it's non-secure temporary and they've served a notice, then it's expired, they're entitled to a possession order and it's a mandatory one. And there's very little you can do to defend that. But the process, I mean, bear in mind that you're talking about waiting for the council to actually get around to issuing, and then the court take a long time to issue papers. So, on an average one, if nobody actually opposed it and there was no complications, you'd probably be looking at 3 to 4 to 6 months.
Okay.
If not longer. Yeah.
That's helpful. Okay, cool. So yeah, I guess that there's obviously a range in that, but that's a typical answer, it seems. Next question is a multi-parter again. So let's just start putting this together. Oh no, not that one. Hold on, getting there. Right, I think that's it. Yeah. So, do you know any way my friend can get an autism assessment? My friend has many traits but undiagnosed. They're under investigation for possession of a knife in a public place while homeless. Under investigation, not convicted as of yet. My friend is waiting for police decision of conviction. The GP has referred my friend for an autism assessment in which there's a 2.5 year average waiting list. Private autism assessment is needed to bypass the 2.5 year waiting list now. So I don't know the answer to this. But what probably my kind of first response would be to again just kind of see if there are any local autism support charities, because they won't be able to do the assessment either, but they probably will have some information that might be helpful. So that's my answer, but it's not a very good one. I don't know if anyone else has got more information than that.
Did we answer this on Monday? Am I being really quiet today?
There was a question about
It was a
autism
similar
assessment.
question,
Okay.
Okay.
What was the answer then? Because I wasn't there. I don't know.
It was they could go private, but it depends on who the organisation takes, how seriously they take private assessment and the waiting list for autism assessments, because it's more knowledge now and it's signs are picked up now. There's a huge waiting list. But with criminal convictions, don't quote me because this might speed it up, because they couldn't hold a trial if they were assessing his mental capacity or her, wouldn't they?
Well, you might be able to get the assessment as part of the criminal process. Yeah, it might be relevant to that. So you could get it
quicker.
If that led to charges being brought, if somehow it was part of the defence, the legal aid agency might fund that.
And
you get a psychiatrist and diagnosis assessment.
And is that does that have to be done? So I know probation kind of write pre-sentence reports and stuff, which would look at psychiatric issues. Is that something which is like standard, or is that only in certain cases?
Certain cases. So there'd have to be a need for it and justify it.
Yeah.
Because the legal aid agency are paying for it, so you've got to have a reason why you're asking for this to be done.
Okay. So yeah, I don't know if we can give more specifics than that, but yeah, I mean, I don't know if that's helpful or not, but I guess there's a bit of info there.
Sorry.
Yeah, go on. No, that's all right. I was about to move on.
If they're waiting for a criminal conviction, I mean, and they have a legal aid solicitor, you can ask them.
Cool. Okay, so I'm multitasking there. Yeah, okay, cool. Next question. No, hold on. Let me get the right one. So, what can a landlord do if a tenant does not have the first month's rent? Can the tenant offer a full amount of the rent in different installments, or can the landlord evict the tenant? Okay, I don't understand the question. I don't understand that question. Does anyone help me out with that? What can a landlord do if a tenant does not have the first month's rent? As in, like,
If you're just starting
as
your
in,
tenancy,
as you
it's
start
like,
your tenancy, and then the yeah, so and then the tenant's hasn't got the money. So yeah, I mean, I get okay. Again, others might be able to give a better answer than I can here, but effectively, if you've literally started, what I'm assuming here is an assured short hold tenancy, unless it states otherwise, then and you missed the first month's rent. I mean, that's yeah. I think that's not like a fatal issue. I think that the landlord first of all can't kind of, it's going to take a long time to kind of start proceedings anyway. But the landlord's first, as I understand, the landlord's first needs to try and arrange a repayment plan with you and something. So that's kind of the first thing. So it's not that they jump to trying to evict you straight away. But does anyone else want to have a give a better answer than I just did?
sorry, I was going to say, so if you're
Thanks, Karis.
starting a tenancy, one of the things council will help you with for private rent is help you with the deposit and the first month's rent. It's a discretionary housing fund, or there's charities that will help fund this. In terms of not being able to pay one of your month's rent, whether it's after this first month and you're subsequently paying, if you can, they'll issue before even proceedings, they'll send you a letter saying, oh, you're in rent arrears, you haven't got this. So you can say, okay, I'll pay it in installments. And if you can prove you can pay it, look, I've just started my job, here's my wage slip, all my benefits are coming through, if they come through on this date, you've got proof that your income is coming in and the date is coming in, and you can make a payment plan from there. Briefly.
Cool. I think that covers it. I think. Thanks, Karis. Unless anyone else want to add to that, or we're going to move on. Cool. Right. So let me just make sure I've not missed one here. There's a question about benefits, which this isn't the place for, because we don't. Yeah, that's not a place. So I mean, the answer is potentially you can always apply for a limited capability for work, but I don't know if you get it. So right, I think this is the next question, unless I missed one. If someone is waiting for main duty to be accepted, is there anything that could cause them from not accepting the duty? Friend is with son and TA are waiting to get main duty, allowed to bid but low priority. So this sounds to me like, okay, so this sounds like this person or this family are in the relief duty, so which means that they can bid, but it's a low banding. So the only thing that can, I mean, assume that the family's not, or the mum's not intentionally homeless, then they're definitely in priority needs. So there might be some really obscure situations where it won't be the case, but in most cases, they will be owed the main duties. Probably the biggest thing or the biggest risk that isn't going to happen is that the council first make either a final accommodation offer or a final Part 6 offer, which is essentially, is an offer of either a 6-month assured short hold tenancy, which has to be suitable, or an offer of social housing. If you turn those final offers down, that's very bad idea, because that can end the whole process. So that's the only kind of things I could think of. In one sense, I mean, I don't know how often actually final accommodation offers are made and final offers are made, but yeah, I think that's the kind of the thing that you'd want to be aware of. But yeah, if you're this family are in priority needs, and assuming they're not intentionally homeless, then really the main duty will be accepted. Now, I guess it could be really pedantic here and say, technically speaking, local connection can also kick in at the end of the process, but it does. I don't know why councils would do that. If councils are looking to refer someone somewhere else, they would be sensible to do it before the relief duty kicks in. So if they're in interim accommodation, the relief duty is ticking along, then I don't think that's going to happen. But I guess, again, technically that could be the case. So yeah, that's kind of my answer. Anyone want to add to that? That'll kind of, yeah, Will, is that yeah?
I would just add one thing that traditionally waiting for the main duty to be accepted suggests that the council are still making inquiries. So, and traditionally that process was where the council would try and find something which would enable them to refuse to take on the main duty. So if they're in prior, well, the fact that they've got temporary accommodation based on having I assume, a child, means that they're over the priority need threshold. They're eligible and they're homeless. So really, it would just be whether they can find an excuse to find them intentionally homeless, wouldn't it? Or they make them an offer. But I think as long as they're okay on those, then like you say, local connection usually comes in at the beginning now, doesn't it, rather than
Yeah.
the end, because they have to refer you and then tell you whether the other authorities accepted you.
Yeah, weirdly, they can still accept the main duty and then refer them somewhere else, which actually would be really helpful if councils did that, because because it would just kind of get more people housed, but yeah, they're not going to.
No.
So there's a couple of comments there, just kind of advice there. So thanks for that. I think this is the next one. So basically, we've now gone over the bit I said we weren't going to take new questions, but we've still got 15 minutes. So I'll see how many we can actually get through in the next 15 minutes without rushing it. I think I've just pressed the wrong button. Yes, I have. Hold on. So which council decides whether you get a discretionary housing deposit, the old place or the new? So it'll most likely, I mean, we might need more information about that. I mean, the basically whichever council is placing you, if that's the right thing, or yeah, if let me rephrase that. If the council's involved in getting you rehoused and they're rehousing in another area, then it'll be the first council. It'd be kind of the council you approach who'd kind of be the ones who are doing the DHP. However, if you've moved to a new area and you're just applying for discretionary housing payment directly for some reason because you want to top up the rent, or I don't know, whatever it might be, then it would be the new council area. So I might be misunderstanding that question, or I might just, I'm not quite sure about that, but I think that would be the answer. If another council's placing you in a different district, then it would be the council that's placing you that's actually kind of have that responsibility to kind of get the DHP up and running. But once you're living in another area, there's nothing stopping you do a DHP application there as well. I guess it just depends on the circumstances. So without more information, I'm not sure. Certainly, I can't give a better answer than that. But anyone else want to add to that at all, or see something that I don't in that one?
Sorry.
If not,
I was just going to add, if it's the old place or new place, if you don't mean borough, if you mean property, just in case you do the old place, like finish off your rent there. If you're changing, both you'll ask the council you're in now, the landlord of the property you're in, at the old place, if you mean property. That might be a stretch.
Yeah. I'm not sure, but hopefully between the two, the answer's there somewhere. So would a solicitor's firm have the ability to facilitate getting an autism assessment through legal aid? Well, hold on a sec. So I think if it's a criminal issue, then I don't know. I mean, I don't know the answer to that, but it's obviously not a housing issue when it's involving a criminal investigation. So I guess that'd be a different, whether there's like a criminal law solicitor who could do, I don't know, but that's not as far as I understand what Virgo's does.
That's right.
Will, you might want to, So
no,
I don't.
Virgo don't do crime, but a firm that does do crime would be able to possibly get an assessment if it was relevant to the criminal case. I'm not sure of the facts of the case and how an autism assessment might help things go one way or the other, but I wouldn't want to rule it out. But if it was considered to be material, then it would be an expense that they could cover. And I suppose if it could come up in a housing context if the council said, right, we're going to find you intentionally homeless or whatever because you had committed this offence. So you could say that autism was relevant to it because it was something arising. If the autism amounted to a disability and there was a link between the two things, then you could have a defence out of that. But beyond that, I can't really say because I'm not sure how having being autistic would leads to you having a knife, but then I don't know the full facts of the case, so there could be a perfectly good explanation for that, which the report would help with. So it could well be fundable.
And correct me if you just said this, or yeah, sorry if you said this. So if you're kind of under criminal investigation, the police would essentially connect you up with a criminal lawyer to support you, right? That would be like default to do that. So you wouldn't have to go looking for a criminal lawyer. They would just give you one.
Yes.
Cool. Okay. So right, hold on. Where do we go up to? So there's some comments there just about some experiences. Again, sorry, I've just had to delete a comment, guys, just about this in the first person. So whoever that is, really sorry. If you could rephrase it to ask the question as a what if question, that would be awesome. So I think this is the next one, unless I missed it. So, and I'm just having trouble copy and paste right now. Here we go. So homeless prevention officer has given 56 days to find PA. What's a PA, guys? I don't know what a PA is.
Like the personal assistance under the Care Act and stuff.
I
Not
don't
Care
know.
Act, yeah. Is it care
The
leavers when they
Children
get
Act.
a personal?
I think in the
personal assistant.
that would be I don't in this context. I don't know if that would make sense.
Private accommodation.
Private accommodation. Cool.
That would make
Thank
more
you.
sense than
Yeah. So okay, right. So when you approach councils, you can guarantee the thing they'll tell you is go and try and find a private landlord, and they know for well that there's not private landlords around that can will take people on the UC or whatever. But if we run through the question nonetheless, so okay, I think let's assume that we're talking about someone in prevention duty. So someone makes a homeless application when they're threatened with homelessness, which means it's likely they'll become homeless in the next 56 days. So they get a personalised housing plan and an assessment, among other things. And the point of that personalised housing plan is to prevent the person becoming homeless. That's why it's called a prevention duty. So there'll be steps that the homeless person or the homeless applicant has to take. There'll be steps that the council says they will take. And in most cases, the step that the person's expected to take is to go and look for private rented accommodation. However, if they can't find any and the council doesn't find any for them either, and they then become homeless, once they become homeless, they immediately go into relief duty, and the PHP should be reviewed and kind of updated because now the person's actually homeless. So it's obviously going to be a different kettle of fish. The relief duty will continue for at least 56 days. If the applicant is in priority need, not intentionally homeless, let's say local connections dealt with, then the council should issue the main duty, to kind of decide that they owe the main duty on day 57. However, if the main duty is not owed, they can extend the relief period if they want to, but I don't see why councils would want to, other than the fact they've forgotten about the person altogether and it's just kind of letting it roll on. So, yeah. Again, I'm sure there will be an instance somewhere in the country where a housing officer actually did a good job, but in most cases, I think they'll just end the relief duty once the 56 days is over. So yeah, and as this person's asked, priority need is where it's all at. Priority need decides so much. If you're in priority needs, even if there's reasons to believe you might be in priority need, you get interim accommodation until the council knows you're not. So if you are in priority need, you're going to get interim accommodation. And then even if you're intentionally homeless, at the end of that 56-day period, the council have to continue housing you for another month or so, depending on they might try and get away with less time than that. So if you're in priority need, you're going to get 3 months accommodation guaranteed. But if you're not in priority need, there doesn't have to be an offer of accommodation at all. So the council just have to, in theory, just kind of try and help you get housed, which is a different thing. So yeah, I probably need to do a separate video about this because it's a really good question, but I think I probably need to go into more detail to do it justice. It gets very complicated. I did do a flowchart last year, which was ridiculous, how big it was and how complicated it gets, because there's lots of different things that can happen along the way. But in a nutshell, that's the general process. So you're threatened with homelessness, you're in prevention duty. If you then lose your home, you're then actually homeless. The relief duty starts. And if you're in priority need, not intentionally homeless, then the main duty would kick in. It should kick in on day 57, at which point you'd remain in temporary accommodation in most cases until the council house you. Now, as I say, they could make an offer of accommodation in the relief stage, but that's a whole kind of another world of complexity. I think there's a couple of videos that you could check out on the channel. One's called "Can I Reject an Offer of Accommodation?" and the other one is called "Will I Get Council Housing or Private Rented?" And I think both those videos kind of touch on this issue of this rather complicated relief duty and how it works. So yeah, cool. Just some good news. That saying it sounds like someone's actually got some suitable temporary accommodation, which is awesome. So just someone saying there's a question under the video, what's the point of personalized plans whenever you get a chance to see it? So I haven't seen that. I could try and have a look in a minute, but yeah, I didn't get a notification now. I'll see if I can dig it out in a minute. So I'll go looking for it. But the next question, there's a two-parter. So let's just put this in. So could someone else have a go answering that whilst I just try and find this other question that's been put in on the video? So as I say, I think it's a pretty common question to be asked. So
Is
feel
this
free,
the one
guys.
where someone requests a review within a specified time?
Yeah.
I could answer that.
Thanks.
Which the answer is the council, if you request, we're talking about a review pursuant to section 202 of the Housing Act 1996, I assume. So if you have a 21-day deadline to request that. So if you do it within that time limit, the council then have 8 weeks to complete the review. At the end of that 8 weeks, you can appeal to the county court under section 204 of the Act. And you've got 21 days from the date when they should have completed the review to do that. So you could be in trouble if you leave it. If you've got 11 weeks from when you request the review to then appeal. If they don't do anything, they could come back and request an extension. You could refute the deadline, but if in this case it doesn't seem like they've done that, they just haven't responded. So I mean, my advice is you should definitely chase them up and say, I mean, what I do with the council, if they don't respond within a week to the request, I write back and say, can you acknowledge receipt of the request? And if they don't do it after that, I then threaten to make a complaint, and then I make a complaint if they don't. So that's on a weekly basis. And then when I get to the 8 week period, at the 8 week point, I would say to them, look, I haven't heard anything. Do you need more time? If you do, please let me know why, and I can think about agreeing an extension. But if I don't hear from you, I'm going to appeal. Now I have to do all that because if I, as a solicitor, take the council to court and they then come up with a decision, I can then ask the court to make them pay the costs for my time of doing that. But it's understandable that if I've just kept quiet and hope that they won't notice, and then I get a load of money out of them, the judge may take a dim view of that. But if so, my view is if the council don't respond to your request within a week, start chasing and make a complaint. But if it's 8 weeks, then get on to making an appeal. But give them a last warning before you do. So I hope that helps.
Just so
Yeah.
you said about making an appeal, how would someone do that? Because you said appeal to the court and stuff, just like so
Yes,
people
sorry,
know.
that's an appeal to the county court under section 204 of the Housing Act 1996, which sounds a bit obscure, I suppose, because it is and weird, but there's a form which is called an N161, which you can get online if you type homelessness appeal appellant's notice or N161 even, or is it 461? Sorry, N161 to judicial review, I think, or the other way around. But go for appellant's notice, and then you fill that in. It's not that difficult. It's a bit like applying for a passport or something. There's just a load of boxes to tick, and then you send that off to the court, and you can email it to them. You have to sort of say why you're appealing, what you disagree with, and then they'll list it. But you really do need a lawyer because even if you can, we've just had somebody come in that I think you dealt with, Mike, didn't you? That somebody who's done an appeal they've issued an appeal on their own, which is quite an achievement, and I'm looking forward to see what they did because it is difficult to A, find the form, B, have the confidence to fill it in, and C, get it off to the court. But the problem is, although you would think that the court would then, on getting it, they'd say, "Oh, we can see you're not a lawyer. We'll try and help you out." They don't really do that. And then you're up against the local authority who'll pay a lawyer. So you're very quickly into a sort of, you feel like you're at a Mad Hatter's tea party and everybody's talking a load of nonsense, um, and you're not part of it. So, but once you've got an appeal issued, you'll find it a lot easier to get a legal aid solicitor because they recognise that it's a full certificate case and they can get paid better than some of the smaller cases. So, yeah, if you can just get the appeal issued yourself, or try and find a solicitor. I know it's difficult, but if you contact Virgo, or leave a comment on here or contact me, I could help you with an appeal. So hopefully that will resolve that problem.
Thanks, Will. Yeah, just to say, guys. So Will's got his own YouTube channel, which he does a live stream on Monday. Now it won't be on this Monday because he's away. But yeah. So I guess that's probably a better way to contact Will or Karis is to just kind of contact Will through his comments on his channel. So I'm panicking slightly because I've just gone to the video that someone's asked about, and there's loads of questions in there which it's not notified me about. So there's like 3 questions. Now the problem is that they're all massive. They're too big for us to answer here. There's like, like pages long. So I'm actually not going to be able to answer that question. So I'm really sorry about that. What I'm going to ask is that you put it through ChatGPT to summarize it. So rather than it being like pages, I'm literally looking at them now. They're like really long questions. It's just simply not going to be possible to answer those questions in this setting, unfortunately. But if you put it through ChatGPT, or if you just try and summarize it, just say, what's the actual question you've got? That's kind of that'll put us in a position to actually answer it. But it's going to be next week now. So just there's a clarification of question 12, which I think might need further clarification again. So we go back to here. So if a person moves from Merton Council to Bournemouth Council, which council can the person go to for housing deposit payments? So if you've just literally moved by your own free will to Bournemouth, and I'm guessing you're now homeless, I'm not quite sure what the situation would be, then if you're homeless in Bournemouth, then yeah, approach Bournemouth Council. But unless you're, I mean, I don't think councils will pay if you're just looking to move. Then I don't see why councils would pay a deposit unless there is some reason to do so. Now, I guess if you were kind of like if you're homeless in Merton and Merton were like, well, you know what, we'll help you get to Bournemouth, then that's possible. I don't know how likely it is, but they might kind of pay some money to get you out of borough in effect. But I don't know. Yeah, if you're not homeless, then I don't think either council would help you out. If you are homeless in Merton and they're trying to relocate you to Bournemouth, or you want to be relocated to Bournemouth, then it's technically possible they might help you out, but quite unlikely. I think they probably wouldn't be that kind of helpful. They'll probably just stick you anywhere. And then if you're actually homeless in Bournemouth, then Bournemouth might help you out, but they'd probably be again looking at whether they're going to owe you a duty, because those kind of discretionary housing payments, they're discretionary. Councils tend to only use them if it's going to save them money. And as in, like, if they're going to owe you a duty somewhere else, then they're likely to actually pay it. Otherwise, they're not going to pay it. As a general rule, you will be surprised sometimes, but it is always worth asking, but it's quite unlikely, I'd say. There's a nice easy question here, which is a bit of relief at the end, a nice short one. So is the council at fault if a person facing homelessness has a PHP, but the person isn't advised to register to housing register? Now, my understanding is it's not even about being advised to register. It's the council should actually do it. I might be wrong about that, but again, in Bedford, if you're under prevention or relief duty, I'm pretty sure they get you on the housing register, provided you supply the documents they've requested. So it's not, I think it comes back to that idea that if you're owed either prevention or relief duty, you get reasonable preference, therefore you have to be on the housing register. That's my understanding. So as long as you're kind of communicating with that, as in like kind of giving the evidence they want, then that should happen. My screen's frozen for some reason, but I think it's all right. Can you guys still hear me? Yeah. Oh, yeah, it's working again now. Okay, cool. Yeah, so as Stella's just said there, so some councils will help, but as I say, just to understand it's generally just a way of them saving money. So generally they won't spend money unless they can save it somewhere else. So if you're not homeless near the borough, then neither of them are going to be motivated to help. So I'm just going to see if this is a question here. Person got help years ago. Old council help with deposit. So housing association now want to refer back to old council because of this. Okay, I'm just going to put this in here. I'm just going to try and see. I'm not entirely sure if this is a question or just kind of a comment. Person got help years ago moving councils. Old council help with deposit. As I say, housing association now want to refer back to old council because of this in prevention duty. So right, so prevention duty doesn't take in local connection at all. So council should not be looking to refer in the prevention duty. That's definitely not okay. Unless the applicant wanted to be, I don't know. Shannon, have you got any ideas on this one?
I just didn't know
Oh,
if
housing
HA
officer.
meant housing. Yeah,
I think they mean housing officer.
I was gonna say advisor, but
Oh yeah, okay, yeah, okay. Yeah, again, so housing advisor now wants to refer back to old council because, as I say, like if you've got local connection to two areas, councils can't like refer you to the other area. They can, yeah, I don't think they could. I mean, they could try and refer you, but the other council would simply reject the referral. So they could maybe help you to try and do it, kind of flying low, not, kind of not doing it officially, but that's again rather dodgy. So I don't quite know how else to answer that. Anyone else got any ideas on that one? I just think it just doesn't sound right, basically. Yeah, local connection does not become relevant until the relief duty kicks in anyway. So prevention duty, although they can talk to the other council, they can't make a referral. Like the prevention duty has to be done by the council you approach. Which brings us very nicely to just gone 8:30, guys. So I forgot to say, actually, if you found this useful, do give the video a like. And if you haven't subscribed yet, yeah, you'll get notifications. If you do, thanks to those who are supporting the channel. It's awesome. Thanks for so many comments coming in, so many questions. I do now need to go and panic a bit more about how many questions I've now missed, because I thought I'd got them all and I obviously haven't. But on that note, if whilst you can ask a question that's like a paragraph, asking a question that's 10 paragraphs is just not realistic for us to kind of really pick it apart. So you're going to have to figure out, as I say, you can use chat GPT to summarize it, and it does a good job of that. But yeah, it's just not possible to really yeah, just to kind of say as well, yeah, just to reiterate as well, guys. So again, asking questions in the first person, yeah, that's not going to work out in this channel. So if you've got a question that relates to your own situation, just put it as a what if question, and we'll try and get back to you. Other than that, hopefully this was all helpful. Will's not about Monday. This will be back on next Thursday. So if you come back here next Thursday, you do. And if I find a whole bunch of questions I've missed somehow, I'll just do a separate live stream at some point. So yeah, but other than that, as I say, hope it's helpful, guys, and keep going, keep doing what you're doing, and just keep it methodical, keep breaking it down into little kind of problems to deal with rather than one big problem. So, but yeah, we'll see you soon, hopefully.
Woo.